Good afternoon, Chairman Tussler and members of the committee. Thank you for having me. My name is Jeff Okazaki. I'm the Clerk of Circuit Court for Dane County. I just wanted to attend today to urge you to support AB 320 on behalf of my office and on behalf of the Wisconsin Circuit Court Clerks Association, representing clerks of court in all 72 counties in Wisconsin. And also wanted to thank Representative Allen and Representative O'Connor and the other authors and sponsors of this bill for their leadership. Many of them work closely with our office and our association in developing this bill that will help bridge the enormous funding gap that we face in county courts. As you heard from the bill sponsors, there are fees that have not changed in over 40 years. I don't think anybody can argue that a $10 item in 1985 costs $10 today. And so we view this bill as a common sense, kind of long overdue adjustment to help keep our court system running properly. I think it's important to highlight that even those who might be concerned about the provisions of the bill, as you just heard, support the intent of what we're trying to do, and we appreciate the Bar Association kind of making that statement. But their position paper on justice system funding says that Wisconsin courts have a constitutional function that requires sufficient funding to meet those obligations, and that the judiciary is dependent on other branches of government, especially the legislature, to provide adequate funding to perform its constitutional duties. It goes on to say that the State Bar believes that filing fee increases should be minimal, and I cite non-existent, and that revenues from said fees must go to support the justice system. I think coming from a group of lawyers, we can probably have a discussion on exactly what minimal means. But I think we can safely say that a $0 increase in 40 or 20 or 30 or even 40 years doesn't come anywhere close to meeting that definition. And I think we can also safely say that the fact that 80% of these fees that we collect don't get retained by the county also doesn't meet that definition of going to support the justice system. And AB 320 addresses all of those items. Despite any differences that we have with this bill, I think we are all on the same page in terms of the need for funding for courts because access to justice is limited by funding. When it takes longer to get to a trial, when we need access to technology for interpreters, when judges don't have the resources for hearings and researching decisions quickly, everything just takes longer. And this means that defendants sit in jail for longer than they should. It means public defenders hold more cases than they can manage. The cost for attorney time goes up. And all of these disproportionately affect the same vulnerable populations that we're concerned about when we're talking about these fee increases. And that is fundamentally why AB 320 is so important, is because it helps make up the gaps in court funding that exist in every single county in our state. And while there are valid considerations around the impact of court fees, when the fees are this ancient, it is time at least to update some of them. And so I think, the other thing that we're looking at too is, the specific arguments, some of which you just heard around who would be affected by these increases. As Representative Allen said, many of these are really red herrings. On the criminal side, only 3 of the 70 or so items in this bill would immediately affect criminal defendants. Totals about $100, $120 increase. Not increasing these fees doesn't mean those current fines go away. So there's no greater impact on the life of a person who would be assessed a few $100s in current fees plus thousands of dollars in restitution to have that additional $100 tacked on. Especially when in a lot of cases, these folks don't have the money and it's not going to be collected anyway. And when we can take the money, it's being taken from somebody who is convicted of a crime and has the money available. And there's also a huge safety net that's already in place. Our judges, as you heard, have the ability to waive these fees. There's only a handful of fees that are set in statute that are not waivable, and these don't necessarily apply to filing fees. And so, we don't have hard numbers. I would say for our really rough estimate that we looked at in Dane County, our judges on average probably waive fees in about 40% of criminal cases, and it may even be higher than that. On the civil side, the picture is very similar. While these may be user fees in some senses, They're fees that have occurred because people have taken specific actions. It's their actions that have gotten them to court, whether it is not paying somebody what they were due or an action that they took against somebody else that caused them injury. So while they are user fees, it's user fees for somebody who has had a hand in whether or not they would participate. And so even on the filing side, for civil fees, a person can win these fees back if they win their case. And so the net cost for any increase to them is still zero. And if the case is without merit, higher upfront fees hopefully, are incentive not to file a frivolous lawsuit, which benefits everybody. And again, there's also a huge safety net there in that we have a structure for fee waivers, including essentially automatic waiver of fees depending on how people qualify. You have in your materials in front of you a copy of our fee waiver form that is available to folks. Despite what you recently heard, Dane County has this available on our website. We provide this at our windows. This is certainly something that is available to folks. There are check boxes on there that say if you qualify for public assistance, if you get food stamps, a number of different items essentially automatically qualify you for the waiver of fees. There's a second section in there that has an area to write down income. And so even if you don't have these automatic qualifiers, our judges then review your income. They review your statement to say that even if you're over the poverty limit, why you may still need to qualify because you can't afford those fees. And so fee increases have no impact on access to justice when you are not required to pay a fee. The other side of this too is right now we are required to pay this fee. All of us are required to pay these costs because counties pay for so much more than the state. This is why this has been a bipartisan issue for us, is because essentially counties pay $171 million even after the budget increase that we just saw, and the state still pays $44 million. And so in order to keep those costs funded, they're funded through the tax levy. And if we don't increase those ancient fees that have not caught up with the cost, that cost is passed on to the taxpayers through the tax levy. And so not only do each of you pay for this cost in the court in your county, but the person who owns the apartment building pays it and passes that cost on to each of the people living there that maybe can least afford it, making it that much harder every single month to make ends meet. And so at the end of the day, we are all affected by these costs. I'd love to go to the gas station and pay 99 cents for gas still, but those fees have gone up. And to say that we can run the court on the same costs today as we did 40 years ago is just impossible.